Welcome, everybody, to How to Fairly and Legally Evaluate Applicants' Criminal History Information. I'm Mike Coffey, President of Imperative Information Group. Just by way of introduction, if we've not met, I'm an HR guy who it'll be 23 years ago this coming January, who got into the background screening business to help out a single client, and now Imperative and our other brand PFC deal with clients all over the country, employers primarily who need reliable information to make decisions about the people they involve in their company. And so we've been honored to do that. I'm fortunate that I still get to spend most of my time consulting with clients around people issues, especially employee selection and performance management issues. But background checks are what we do. And of course, that involves always criminal history. And we've spent a lot of time over the last 23 years working with employers, not just on making sure their background checks are thorough and all of that, but also in making sure that they're being fair and legally compliant in how they consider applicants' criminal history. I also will say I've got training that I do for former offenders to help them find meaningful work with a record. I think that's also a very important thing for somebody in my industry to be involved in, but for HR professionals in general to be thinking about a lot more than we normally do. And I'll have a lot more to say about that later on in the webinar. So this presentation is pre-approved by HRCI and SHRM for 1 hour of recertification credit. And if you're watching the webinar live, you will get that credit via email following the conclusion of the webinar, probably tomorrow morning. Give my team a little time to sort through everything. But then if you're watching it on the recording on our website, then there will be a slide near the end of the webinar that gives you the code so that you can enter it, demonstrating that you watched it to the end, and that'll deliver the credit to you. So with all that said, feel free, let me say, to drop questions in the chat box throughout the webinar, and I will do my very best to answer those questions as we go, especially if it's relevant to that specific slide, or if it's something that we probably haven't covered. Otherwise, I'll catch the rest of them at the end of the webinar. So let's get started. Do me a favor and jump in the chat box and just let me know if your organization has a policy covering the use of criminal history information. And now I'm not talking about a background check policy necessarily, but more generally, or more specifically focused on criminal history, not just the information you get from your background screening company, but how you evaluate it as a company, how you make decisions. Aaron, you need one. Okay, well, we'll get started here today, and we have information that'll help too, that I can share with you. Shoot me an email. Creating one for a client currently. So, okay, good. So it couldn't have come at a better time. We have a process. That's always interesting because processes are different than procedures and different than policies. And they sometimes, depending on the organization, vary over time according to who's dealing with it and who's making decisions. And so we'll talk a little bit about some of that. I mean, look what else we got. Some people are unsure. I don't even know if we've got a policy, which, if you're not involved in the hiring decision or in whatever the rest of your process for selecting and screening employees, that may make sense. But if you're in the recruiting process and in the hiring decision process, and you don't know if you've got a policy, then you probably don't. Or we're doing the old thing that we always hear about, is we're evaluating the criminal history on a case-by-case basis, which often means that we're letting our hiring managers make that decision without a lot of guidance. And let's face it, they're not even good. Most of our hiring managers aren't even good interviewers. They You could, there's a study out there that says that randomly selecting a minimally qualified candidate just based on their application is more successful than letting hiring managers actually interview people, because our managers aren't trained to do these things, and we expect them to be because they were a great accountant or they were a great worker in whatever field, and so we make them managers, and we don't always train them as well as we ought and give them the tools they need to make good selections. But the reality is that we all have biases, and there's no way we're ever going to get rid of those. But we can be aware of those biases and how they affect the hiring decision. But we can also put guardrails as HR. We can put guardrails around the hiring decision to help people's biases from more than we would like affecting the hiring decision. So it's interesting. I appreciate the feedback on that, and let's talk about why do we even care about background checks, okay? And criminal, or why do we care about criminal history more generally? Well, the bottom line is what our employees do while they're on the job or at other times where they can be associated with the company affects the company. It affects the safety of our employees, the safety of our customers. It affects the safety of the general population, our broader community in some instances. Also, affects the financials of the company if people have access to easily removable assets or our inventories, things like that. And certainly if they do something knuckleheaded, it could cost us customers, all of those things. So while employees are on the clock or even off the clock, they can affect the trust that the rest of our workforce has in our organization, that our customers have in our organization, and that our broader community and all our other stakeholders have in the organization. So what we hope is that past performance gives us some insight into future performance. Now, there are multiple ways that employers use criminal history. And the one you hear the most about, and the one that certainly the EEOC has addressed most seriously, and many people just assume this is how employers are using criminal history, is that they're using it just to eliminate applicants. Okay, you've got this history, so we're not going to hire somebody with this history for this job period, so move on down the road. And certainly in some cases that makes sense. You see, you may not want this guy here on the left, especially if he fails this field sobriety test, driving the forklift in your organization, if on the front end of that forklift is a bomb. And that's what that is. That's a bomb on the front, and maybe it's a bomb on the left, in the left-hand picture too, we'll see. But certainly that's one way we use criminal history. Sometimes somebody's criminal history is enough because of its recency and the kind of behavior involved that we just eliminate them from consideration. Certainly we do background checks for nanny agencies and domestic staffing agencies all over the country, and tons of families who are hiring a nanny or hiring some sort of household staff. And you can imagine, there are a lot of offenses that a family just says, I'm not comfortable having that person care for my child with that history. But that's the extreme narrow position, and probably one of the most risk-sensitive positions that we screen for. But somebody just working in your warehouse, there may not be as many offenses out there that are giant red flags that you're just going to say, no, we just cannot hire somebody with that history. But the history may still be relevant. Let's say it's a medium risk offense, and we'll talk about how we determine that. But if it's a medium risk offense and you're looking at the rest of your, let me go this way and that way, there we go. You're looking at the rest of your candidate pool, then maybe you can compare this applicant to these other applicants. So in this example here, we've got Dick. Dick on the left has 9 years relevant experience. He's got an MBA. His neutral job references came back fine. He performed well during the interview, which is never a reason to hire somebody. I always worry about that because so many of our clients are, well, he was so charming. I can't believe that he did this to us. And so some people just interview better. And I think that's another bias that we have to watch out for. But Dick had no criminal records reported. Now we've got Tom, and let's, for all purposes, Tom is equally qualified. But in 2020, Tom had a theft by check. In 2019, he had an open container violation. In 2018, he had a failure to appear on a ticket or something like that. So when you're looking at these two candidates, Dick or Tom, and who do you want to interview first or who you're going to pursue? Well, clearly, Tom over here is the one who doesn't seem to be managing his business pretty well. And I don't know about your organization, but in my organization, I'm not looking to hire people who need more management, who are going to take more effort from my supervisors or from me to manage and make sure that they're taking care of business. I'm looking for somebody who's self-management, somebody who's compliant, somebody who's safety aware, all of those things already when I walk in the door. I can give them the skills to do the job. But if their recent history tells me they're just kind of a knucklehead, they've consistently made these errors, I'm not necessarily looking for more work and bringing somebody in and having to do this additional management over what I would have to do with a regular employee. So assuming I've got multiple candidates for this position who are fully qualified, I'm going to look at those applicants who pose the least risk to my organization. Sometimes it's just the amount of management time we expect they may take. And other times it's behavior that's directly related to the job. And we just say, that puts them at high risk. And so we're going to look and see if we've got other candidates we can work with before we dig that deep into our candidate pool. But we're recording this webinar in December 2021, and the labor market is pretty hot. And employees, people who will actually show up for work, heck, if they'll show up for the application or for the interview, their employers bonusing people just to show up for the interview. But if they'll show up for work and they've got a pulse, a lot of employers are just hiring people, right? So we may not be quite so selective about people's criminal history. We may build controls around positions so that they don't have as much opportunity, maybe, because that's the only applicant who's available and preliminarily qualified for the position. So when I'm talking about a bulletproof background screening process or bulletproof screening process, I keep saying background because I'm talking about background check, but a bulletproof screening process starts with your job description. And we'll talk a little bit about that, and your policies and your tools, your employment application process and your criminal history inquiry, then gets into the interview and how you discuss past performance, both on the job and criminal history and all those things with your candidates, and then the background check. In this scenario, the background check should just be a lie detector test. And if you were with me on the last webinar that we did, 7 steps to bulletproof hiring decisions, I kind of go through at a high level all of these steps. And today we're really talking about that piece where we're evaluating the criminal history, the policies and tools. So the applicants have given us their history, and before we've ever done a background check, we've at some point we've asked about applicants about their criminal history, and now we're going to evaluate it. And ideally, if they're honest with us, then the background check comes back, with whatever they've told us and nothing else, and the background check just verified that they did, they were honest with us. Now, I would be out of business if all your applicants were honest. And so you do need to verify this stuff, but assuming the applicants were straight with you, we need processes to make sure that we fairly evaluate the information and don't let too much bias enter into the hiring decision. So first, we've got Title VII, okay? In 2020, in 2012, the EEOC came out with a new guidance around criminal history based on Title VII. So Title VII, we all know, prohibits discrimination in the employment context on race, color, sex, national origin, and religion. You notice criminal history is not one of those categories. Well, the EEOC and the court cases out there suggest that Title VII is still implicated when you're evaluating criminal history. And so let's get into that. First of all, Title VII talks about disparate treatment. That's how the law was originally written, right? And we know that when we see it. That's the kind of discrimination where we see somebody's characteristics there, race, sex, national origin, religion, color, based on just those kind of factors that are not job related at all. We say we're not going to hire those people because of that job, because of that demographic or that being in that, having that characteristic. That's just outright discrimination. We know it when we see it, and it's widely accepted that that's not how we should be running our businesses. So that's disparate treatment. But then in 1972 or 1971, we had the Griggs v. Duke Power case. And in that case, basically, the court recognized that there are situations where we negatively impact a group that's protected under Title VII, even though there's not a strict policy or an intentional act even to discriminate against those folks. So in Griggs v. Duke Power, for instance, Duke Power had created a policy that said in order to be a supervisor or manager at Duke Power, you have to have a high school diploma. Well, this is in the South in the 60s, when African Americans were less likely than the white population to have a high school diploma, just because of the circumstances there with racism and funding of schooling and the whole host of issues. But statistically, African Americans were less likely to have the high school diploma than the white population. Mr. Griggs, who worked for Duke Power, wanted to be a supervisor, and they said, no, you don't have your high school diploma. We do have a program where you can get your GED and all of that, but you can't be a supervisor at this time without going through that process. Well, Mr. Griggs sued, saying, well, and he demonstrated that, well, before you implemented this policy, you had white supervisors who didn't have their high school diploma, and their performance is no different than those with high school diploma. And if we're honest with ourselves, whether somebody got a high school diploma 15 years ago or not, probably isn't really all that relevant to how they're going to perform their job today. But because this was, like I said, a circumstance where African Americans employees were less likely to have that diploma than other people, and the policy couldn't demonstrate a reason for existing. You couldn't, based on the policy, show that there was a business reason for this. The court recognized you're creating a discriminatory impact, a disparate impact on African Americans with this policy. And that's where we get the idea of disparate impact. And then we roll around to, I believe it was 1975, with the Greene versus Missouri Pacific case. Mr. Greene was in the 60s, a Vietnam era war protester, and refused to register for the draft and ended up in federal prison for 18 months, I believe it was, because of those activities. Gets out of prison. Several years down the line, he applies at Missouri Pacific to work for the railroad. Well, MOPAC at the time had a policy that said, we won't hire anybody with a criminal history, period. And their idea was, that's not a violation of any law. That's not discriminatory, because it's not race, sex, national religion, color, any of those things. And so we're not creating, any kind of discriminatory environment that's, against a protected class. Well, Mr. Greene argued that because African Americans are arrested, prosecuted, and convicted at a higher rate in the U.S. Than the white population, having a policy like that is creating a disparate impact on the African-American population. And that you've got to have a business argument. There's got to be a business need for your policy. And the fact that somebody got caught shoplifting 20 years ago, or that 7 years ago, somebody was in federal prison because they were protesting the Vietnam War, and you don't even evaluate whether that's relevant to the job or not, is creating a disparate impact. And the court agreed with them. And so that's where we get the Greene factors. And the court basically said that employers in your use of criminal history needs to have a way of evaluating what that, what the risks associated with the job are, that there's a business reason for that. Because if they can demonstrate that you're creating a disparate impact, that statistically you're causing injury to a protected class at a greater rate than the majority population, and you don't have a business reason for it, that's disparate impact, even if it's on something like criminal history. So the important thing to take away from the Greene decision is we need to look at the whole applicant, right? And what we don't want is a criminal records Brightline rule. And I see this from time to time in job postings: clean background check required, no felonies allowed, no convictions for theft or dishonesty. And I still come across employers with these kind of policies, and they do not mean those policies to be discriminatory. That's not their intent at all. They think these are good policies. But again, let's just talk through some of those. Clean background check required. You're telling applicants, hey, if you've got something negative in your history, don't apply. Because, it sounds like, at least, even if it's not what your practice is, that you're not going to fairly consider them. No felonies allowed. And that's the one that raises employers' eyebrows sometimes, but let's think through that. In Texas, where I'm based, your third DWI is a felony. So let's assume somebody got their third DWI 10 years ago, and all they're going to do in your organization is drive a desk. They're going to sit behind a desk all day. They've got no criminal history in the last 10 years. They've just got this old series of DWIs, and one of them was a felony. Does that really eliminate them from employment, doing something that isn't a really safety sensitive position where they're operating a forklift, operating some kind of heavy or dangerous machinery, or operating a motor vehicle? I would argue probably not, but you'd have to look at the whole context, but you want to evaluate that against the risk associated with the position. And then no convictions for theft or dishonesty. Again, I see this one a fair amount from employers. And so somebody got caught shoplifting, or they wrote a hot check 10, 15 years ago. Are you going to eliminate your otherwise fully qualified candidates based on one incident all those years ago that was maybe just even a misdemeanor? Now, if there's embezzlement and they're your CFO candidate, maybe you rethink that. Maybe that's a lot more impactful because of the role of the job and the circumstances behind their prior criminal history. So, but the bottom line is we want to look at the whole applicant, and we don't want a Brightline rule that just says, if you fit in this category, do not apply. Or even if you don't say it that way, internally, we're not going to consider that. It's not how you want to do business. And then, like I said, in 2012, the EEOC came out with their new guidance, or their latest guidance on the use of criminal history. And they introduce the Greene factors, which came out of the Greene versus Missouri Pacific case, where the court suggested, by the way, they didn't say employers must, but they said employers may consider items like the offense itself, how long ago it occurred, and the responsibilities of the job, and how those three things, the age of the offense, and the job, how those things intersect, and if there's a business reason for that to be of concern or not. But then they went beyond the Greene factors and created, basically out of whole cloth, this idea of individualized assessment, because there's nothing in Title VII and really nothing in any case law that says this is the law. But the EEOC basically said that employers, in order not to get too much scrutiny from the EEOC, or this is what the EEOC, when they investigate a complaint of discrimination based on a disparate impact in the use of criminal history, we're going to look at these things. And so let's go through what those individualized assessment items are. I don't agree with all of them, and the courts so far often haven't either. And there are whole swaths of the country where the federal courts have said, in this district, we are, the EEOC guidance isn't valid on this point. But all the same, it's worth, a lot of these are worth incorporating into your policy process. And so I wanted to talk through each one of them. First of all, the EEOC said your individualized assessment ought to consider the facts or circumstances surrounding the offense. Well, that makes sense, right? What did they do? What were the circumstances where it occurred? That makes perfect sense. And certainly it's a question it's a conversation you should have with your applicant. That's easy enough. The number of offenses for which they were convicted, I think that's really key. So in my consulting with our clients, there are times where somebody has a series of recent offenses, and those offenses don't relate to the job. Okay, let's say they've got a public intoxication, a failure to appear on some traffic tickets. Maybe they even have a simple assault a couple years ago, or a theft by check. Little minor things that, in and of themselves, if it's just one instance, we wouldn't be too worried about. But when we start to see them line up, and especially when they're fairly recent, again, this goes back to this is somebody who's kind of a red flag. Their behavior is alarming. But certainly, if you see somebody with a DWI, an assault, some sort of theft, and got all these different kinds of history over time, and more significant offenses, that is obviously something that you're going to take into more consideration than just somebody who just had a DWI 5 years ago. Now, this is where the EEOC kind of is looking for employers to become social scientists. And quite honestly, without really, I think, enough science out there for employers, to really be able to apply this. But there are studies out there that say that the older you are, the first time that you are convicted, or if you're older when you're released from prison or from supervision, if you're on probation, things like that, you're less likely to commit another offense. But that's, how do you know what, that's a generalization based on a big study of people. But how do you know when you're dealing with this applicant that that's the case? And I think, it gives me pause for them to expect employers to be able to consider that effectively. I'd be more concerned about how long ago the offenses were than I would be how they were when they committed their offense. But there are studies out there that suggest, for instance, that the younger you are, when you commit your first offense, the more likely you are to commit additional offenses later in life. So for what that's worth, but I'm not sure that this is something that's really many employers can effectively consider in a way that is helpful to them or to the candidates. They also want you to look at the kind of work that the person has performed after that conviction. So after the conviction and after whatever supervision, or whether they were in prison or whatever, what kind of work have they done? Is it the same kind of work they've been doing for other employers in a safe manner, and as far as we know, without any incidents? That certainly makes sense for an employer to consider that. when you're looking at the whole applicant, you're going to do that anyway, right? We're going to look at their skills, their competencies, their work history, and make some determinations based on all of that. And their criminal history just happens to be one piece of that. And then just their overall employment history before and after the conduct or the offense. And certainly we're interested in that too. Is this a blip in is this just a blip in their behavior, just one of those, really crucially bad decisions that they've made in their lives, but everything else before and after suggests that it was an aberration. And that can make sense for employers to consider that. Rehabilitation efforts. What have they done as far as getting an education or training? And again, this gets back into the social sciencey stuff that I think it's not necessarily fair to expect employers to consider, especially since they don't really give you a lot of guidance. But the fact that somebody, while they were in prison, completed a Microsoft Word class or did things like that, maybe got a high school diploma, maybe that speaks for them or maybe not. But what it doesn't show is how they perform outside of that kind of supervision. But certainly somebody who gets who really excels and moves themselves forward during that time, who gets a maybe not just a high school diploma, but gets a college degree, and maybe once they're out of prison, out of supervision, they get a higher level degree, they gain some certifications maybe that are unique to your industry. They do those kind of things. Maybe that is effective, but there's, as far as I have seen, there's no evidence that that these kind of that training and education is more, says that somebody's less likely to recidivate or be a model employee because they've gone through those things. Those are certain things you want to consider on the broader scale as you're looking at the whole applicant, but having this as something that the EEOC is going to try to measure you against is kind of concerning to me. Then employment or character references. Okay, certainly employment references. If you're talking to a former supervisor and you've confirmed, because we see a lot of people list their friends, and we, as a former supervisor, and we figure out in the verification process that that person either never even worked for that company or that they, they worked together, but this person wasn't a supervisor. But if you can really verify that this person has the skill sets and that their experience really lines up with how they represented it, maybe that certainly is something that you should consider. But character references, I think those, the personal references part of your employment application, all that is an intelligence test. Is this person smart enough to list 3 people who'll say nice things about them? And we have clients who are, especially those in some regulated industries where they have to do personal references. They have to go verify 3 people, 3 references, or at least attempt to. And so we do those for them. And most of the time, they say how amazing this person is, and they're walking on water. But every now and then we get hold of somebody and they say, he listed me, and then they throw him under the bus for the next 5 minutes. Okay, so, but the fact that this guy's pastor or minister says nice things about them, for me, is not particularly persuasive as to whether that is something that should overcome the risk suggested by their criminal history. And then they point out that there are federal and state bonding processes, which basically insure an employer against loss if they hire somebody with a criminal history and that person does something against the employer and that costs the employer some loss. But here's the trick. When you really dig into those programs and those, insurance policies, the reality is that person has to commit an offense very specific to and similar to the offense that they were previously convicted of. And so if their previous offense was theft, then and in your organization, they assault somebody, or they, do something, they drive drunk and injure somebody or something, that behavior isn't covered by these kind of bonding programs. And so the reality is when, we look at a ton of background checks. I see them every day. And most people's criminal history isn't consistently theft. Most of the time it is a theft, an assault, a failure to appear, a public intoxication. It's all kinds of things, because most people aren't just dyed-in-the-wool thieves. They're not professional criminals. They're just people who exhibit poor decision-making, poor self-management, poor safety awareness, those kinds of issues. And so these programs, may or may not pay out. But the even bigger issue is, if you ever have to collect on one of these programs, the horse is already out of the barn. Okay, they've already committed an offense that cost you a loss. And so the fact that you're insured against the loss, I would argue, is not the reason to hire somebody, that doesn't mitigate the risk that they suggest for the organization in putting that person with that offense in this particular position. It's nice to have, and I certainly encourage anybody who's got an active program for giving former offenders a fair shake at employment, or maybe you've even built a culture around that. That's amazing. And I would encourage you to participate in these bonding programs, but don't hire somebody just because. That's like giving the keys to your car to somebody who is not a good driver, and say, I've got insurance if they wreck it. That's not that's not how you want to handle that. And likewise here. And so I wouldn't, even though they want you to consider that, I wouldn't give it a ton of weight, because you don't want to suffer the loss to start with. So when do you ask that individualized assessment stuff? This is the individualized assessment question we suggest clients consider. That this is a sample that we give them. And on our criminal history inquiry, we include this question right there. So after we've asked them about their criminal history, and the criminal history needs to be specific about specific states and even local municipalities that have their own limitations on what you can ask and when you can ask. But given all of that, when you can legally ask, and you ask the question you can legally ask, then I suggest you put that individualized assessment question to the applicant. So you've asked them about their criminal history, they've told you what they've got, and now, and I always want this in writing, you can ask them, hey, tell us about the rest of the circumstances. If this doesn't reflect the right, full context of what happened, give it to us. Help us understand what happened here. And we include that right on the criminal history application document. And then the other time you can do it is on the background check document. So you order the background check, and as you know, under the Fair Credit Reporting Act, you get the background check back. And if there's something that may adversely impact the hiring decision, you've got to give a copy of the report and a copy of the consumer's rights under the law to the applicant. Well, why not include the same thing there in that cover letter, saying, hey, and here's your background check, here's your rights. We may, take an adverse employment action based in whole or part on this information. But hey, if there's additional information that would help us understand the context of the information on the report, please share that with us. Those are great places. I also think just doing it during the interview, have the conversation. Especially if you've already asked them about their criminal history on the application, then you sit down and talk to them, give them an opportunity to tell their side of the story. And it may be persuasive. It may give enough context, but always verify whatever they've told you. Because again, if they were all reliable and honest and trustworthy, I'd be in a different business. So what if you ask that question on your criminal history inquiry, or when you get the background check back and you send them the pre-adverse action information and you don't hear any response? Well, the EEOC said, well, then you don't have to wait for that response. You don't have to beg them for it. The fact that they didn't respond is sufficient, and you can move forward. Now, the EOC guidance does, and this is in 2012, does suggest that employers ban the box or remove the criminal history inquiry from the employment application. Now, I've got a whole webinar coming up, and you can look on our website to see the schedule on just how and when you should ask the criminal history question, how you should have that conversation with your applicants about their criminal history. And it's an hour-long presentation, so I can't get into it too deep here, but I'll say my personal opinion and my own experience over the last 23 years working with employers, that is malarkey. Okay. If you've got processes like we're talking about here in place, where you're going to fairly evaluate that criminal history against everything else the applicant brings to the table as far as qualifications and competencies, then I think you ought to ask the criminal history question right up front. So you can evaluate the whole applicant just against all the other applicants fairly and evenly, just like you would be concerned about what degrees they have, what schools they've gone to. All we care about from the applicant in their employment history, all of that is about past performance predicting future performance. And the criminal history is one piece of that. And so I'm not a proponent. It doesn't, and as a background screening company, it doesn't really affect me because my clients don't even run background checks generally until after they've made an offer, because they don't want to waste the money on a background check if the applicant turns it down. So it doesn't really affect me as a background screening guy, but as an HR guy, I want as much information as I can legally have about the applicant that's relevant to help me predict how they may perform in the future in our environment. So what does it look like? How do you really evaluate that? Well, ideally, for a class of positions, and this is what, when I'm consulting with a client one-on-one, we help them put this together. A class of positions, like let's say admin clerical positions in our organization that never drive a car. Certain offenses are going to be low risk, and by themselves, they're not of concern to us. Some offenses may be medium risk because of their relationship to that specific job, kind of job, and the controls that we have in our organization, those kinds of things. They may be a medium risk, and then there are going to be some offenses that are just high risk. And even a high risk offense doesn't mean that we're not going to hire that person. What a high risk offense means is that's high risk. And we're going to evaluate that high risk against everything else in the context of the employment decision. So we may still hire them. There may not be other candidates with that qualification, or it may be the vice president's son or whatever else. There may be reasons to do it, but we still are saying before we've ever met the applicant that this criminal history is high risk related to that particular job. And then we've got some tools. And again, we've got an upcoming webinar on building all of this stuff out. But ideally, you build out this checklist that looks at the risk associated with the job. And then you tie it to specific pieces of, tie those risks to specific kinds of behavior. So here's kind of what it looks like. Our position risk review checklist looks at the kind of access this person may have in this role, what their supervision level is or their work environment looks like, the job responsibilities. Also, it looks at regulatory requirements for the job. And when you look at all of those things together, we're saying, okay, this position has access to personally identifiable information. They've got access to social security numbers, dates of birth, information like that. Well, that's a different risk profile than somebody who doesn't have that access, but they're operating a motor vehicle or some heavy equipment. And so we go through all of these kinds of issues to identify what the risks are associated with this job. And again, these are classes of jobs. So if you have in your organization, let's say there are, you've got 300 different job codes, you've probably got broader classes of them that you can put together where, like I said, admin clerical, who never drive versus admin clerical people who may have to drive and go to the post office or run to the supply, buy supplies or things like that. You get that group of people. Then you've got warehouse, and you've got warehouse maybe who operate a forklift or heavy equipment, and those folks who don't. And so you can usually, most of my clients, when we sit down and do this, end up with just 4 or 5, big categories of jobs. Because what we're really looking at is generally in our environment with our controls, what are the risks associated with these groups of jobs? So you go through that, and then what you see here is across the top, those same risks we've identified, personal access to personally identifiable information. In this case, we said, yes, they have that. And you've got all these other kinds of risks that we've associated. And we've got a standard list of those risks. But sometimes clients have to develop their own. just because they're in unique environments. But we go through there, and then we start tying the risk we've identified back to specific kinds of, or kind of general kinds of criminal offense behavior. So crimes against people, financial crimes, property crimes. We've got a whole list of those just broad categories of crime. So, financial crimes, would be theft, fraud, embezzlement, credit card abuse, things like that. And then property crimes are, robbery, shoplifting, possession of stolen property, theft by check, things like that. So you've got a variety of these different kinds of behaviors. Then we take that, once we've identified what the kinds of past category of offense that tie to the specific things in this job, the specific risk in this job, then we can go and create the position risk matrix. And so when you do that, you get to the point where you say, okay, here's what we're looking at. Certain kinds of offense, and you see we've got 0 to 3 years, 3 to 7 years, and 7+ years. And you see, some things in the last 3 years would be a high risk. In the last 7, they may be medium, and in 7+, they would be low. While there may be other offenses that are low, even if they're recent. By themselves, they're low. Now, this person we've categorized as an IT manager, so it's kind of, they're supervising people. It's probably one of the highest risk roles in your organization. They've got access as the IT manager. They may have access to all kinds of PII and private and confidential information and proprietary information. And they also supervise other people and can be pretty much anywhere in the organization without anybody raising any eyebrows. You've got all kinds of issues with that. So you may have more things that are higher and medium risk for that role than you would other roles. I think people tend to underestimate the risk associated with their telecom and their IT infrastructure folks. And I'll tell you the other group that people underestimate are the folks who work in your maintenance and janitorial staff, housekeeping. Those folks, they've got the keys to the kingdom. They walk all over the organization. They can be anywhere. They're often there after hours when there's very little supervision. And I think people say, oh, well, we only pay them $10 or $11 an hour. And so I'm not really worried about it. What you're paying them doesn't have anything to do with the risk that they pose to the organization. So, and like I said, I've got an hour-long webinar on just putting this stuff together, but it kind of gives you the high-level overview of this information. So let's talk about some of your other policy issues. What do you do about dismissed cases? Because we hear this all the time. My lawyer said this wasn't going to be on my background check. Well, criminal defense lawyers don't understand how background checks work. And under federal law and in most states, an employer can consider a dismissed case. Even the EEOC in their 2012 guidance said employers can even consider arrests if the underlying conduct, if it's reasonable to believe the person engaged in the underlying conduct. And so one good example of a dismissed case is a deferred adjudication, right? So if a case is, if they get deferred adjudication or pretrial intervention, things like that, in most jurisdictions, what that means is that person pled guilty or no contest to the offense. They accepted responsibility for the offense. And then in exchange for that plea of guilty or no contest, they agreed to serve probation and the case could be dismissed. And so it's not a conviction on their record at the end of after they serve the probation. This saves them from getting a conviction, but you as the employer, according to the EEOC, your concern is whether it's reasonable to believe that person engaged in the conduct. Okay, so if they engage in the conduct, that's what you care about. So if they pled guilty or no contest in a deferred adjudication, then I would argue you look at that where you can legally, because there are some states that limit it. But where you can legally, my recommendation is to look at it like they engaged in the conduct. You don't really care that this person had a better lawyer than this person and got a better deal. Is it reasonable to believe they engaged in the conduct? And if it was, then let's look at that. And there may still be cases where even a straight dismissal, a case that was dismissed for maybe because of lack of evidence, you may still be interested as an employer in that legally. The cases get dismissed for a lot of reasons. So at the very least, you want to have a conversation with your applicant and say, tell me what happened here. What was this theft case that was dismissed? Tell me how it happened. And sometimes the applicant will tell you enough about it where they just the behavior that they admit to is concerning enough to cause you a red flag, because the underlying conduct that they admit that they did engage in is sufficiently concerned. And so you do want to always, where you legally can, and if you're in California or if you're in New York, there are specific limitations on what you can ask and what you can consider. But in most places, you can still ask about them. And I think you want to have that conversation. It's icky. Nobody likes to have that conversation with people, but I think you want to have that conversation so you understand what happened there, so you can fairly evaluate it. If you're operating in a vacuum it's, you just say, well, we officially don't consider those things, but I've got this other applicant over here, and you don't ever have the conversation with the applicant about, who's got this history, then you're probably not giving them a fair shake to trying to understand what happened. Classifications of the offense. Is it a felony or a misdemeanor? And I talk about this in some of the other webinars as well. And but I would argue that it doesn't matter. Felony and misdemeanor classifications are all about punishment. They're about the level of and the severity of punishment somebody can get based on certain activity. And that's not your concern as an employer. Like I said earlier, your third DWI here in Texas is a felony. If somebody got their third DWI 5 years ago or 3 years ago, I may not care about that because their job doesn't involve driving or operating heavy equipment or doesn't require a specific level of safety awareness. But if they had a misdemeanor theft 3 months ago, I might be very concerned about that role in certain roles. But if they're going to be working in accounting or as a cashier or with access to easily removable assets or in people's homes, that 3-month-old misdemeanor theft may be enough to cause me concern to keep looking for other applicants. So I see all the time employers who only ask about felonies, things like that. And I think that's a big mistake. And again, when we get into the conversation you should have with your applicant, the upcoming webinar on how to discuss criminal history with your applicants, we get into that a little deeper, but don't get tricked into that idea that felonies are worse than or more relevant than misdemeanors, because they may not be. Well, what about pending cases? And that's always a hot issue. He hasn't been convicted yet. Well, again, the EEOC's advice in their guidance was, looking at it, is it relevant to believe this person engaged in this conduct? And so you've got to have the conversation with the applicant. Okay, so he says, I've got this sexual assault case filed against me, and and we may not go to trial for 18 months. Well, and you look at your criminal history matrix that we put together, and you said, okay, well, the sexual assault is high risk, and for this particular position we're considering this person for, and so you want to ask them, tell me what happened. Well, what they're going to tell you is, my lawyer told me not to talk to anybody about this. That's good legal advice from the lawyer for that person, but you as the employer, you have a right to ask about this, and so you understand what risk this person may present in your organization. So my advice is always, if that pending case is medium or high risk, or if it's something that they could actually go to jail for and be unavailable for work, you may not want to invest the time in recruiting or in training and onboarding and training this person for this role if they may not be available, or if they're medium or high risk. You take care of your business first, and then we will come back and you can reapply when there's a position available at some point in the future for this, and we'll evaluate it at that time. But pending cases shouldn't necessarily automatically eliminate anybody, but you want to look at it just like all the other risks associated with other behaviors in the organization. And if it got warrants, my advice is always, if you're wanted, you're not wanted here. Go take care of those warrants. And I advise a lot of times clients call and say, hey, this guy's got no history except for these warrants that you reported on the background check. And he says he didn't even know he had the warrants. And my answer is always, okay, we'll let him go take care of them. Give him a week. Say you've got 7 days to take care of those warrants. You go pay those tickets. You go show up at the police station. You do whatever the warrant's for, and get it cleared up, or take it to the next step, and then come back and talk to us, and we'll reevaluate it. So, if it's a warrant for an unpaid traffic ticket, you go pay that traffic ticket. Probably, for a lot of jobs, that's fine. But if it's I've talked to applicants who called me who were angry about or saying, what do I do about this background check on the this person's warrant, this warrant on this person's background check, and the applicants are saying, I can't show up because if I show up, they're gonna arrest me. And well, yeah, that's what warrants usually mean. And so, but why would the employer take that position of hiring that person if they could be disappeared tomorrow? They could, and end up in jail someplace and not be available. So take care, require that your candidates, make that your policy. Candidates have to go take care of any outstanding warrants. And I'd advise that be for your policy with regular employees too. If you do annual or periodic background checks of some sort, and you see that somebody's got a warrant, damn, you got to take care of those. You cannot be an actively employed employee with us if you've got that warrant hanging over your head. What about attempted offenses or conspiracy to commit an offense? You see this attempted burglary, attempted sexual assault, conspiracy to commit fraud. Well, my argument is you don't really care if it's attempted or if they got away with it. Just the fact that they're a bad criminal and they're not good at doing criminal stuff doesn't mitigate anything. Their intent, the underlying conduct, is what you should be concerned with, right? They were trying to do this. They attempted to do this. Their intent was to do that. Consider it just like on your matrix, whatever level of risk that offense was originally, how you categorized it before you ever met the applicant. And what about repeat offenders? We remember Otis from Green Acres. He was always, not Green Acres, Mayberry RFD and Andy Griffith show. He was always in jail. He was just that regular guy who's just always in some sort of trouble. First of all, you want him to be on an ongoing basis available for work. And so that's, something to consider. But also people who don't self-manage, who aren't safety aware, who aren't compliant, are those the candidates that you're actively looking for in many circumstances? And you may see that just that constant drumbeat of being a knucklehead, they're self-identifying through that to you that they're going to be the kind of employee who may take more management than other employees. Now, you may have somebody who says, look, I had this history in the last 18 months of consistently being in trouble. And 6 months ago, I got sober and I joined AA and I've moved beyond that. And this is who I am. That, if their history supports it and that may be an applicant that you're willing to take that risk on, that even though it's medium risk because of the number of offenses and all that, you've said, what, you've demonstrated to me that you're in meetings or you're doing whatever process that you're going through to get things straight. We'll you've got the skills and the other qualifications for the job. We'll go ahead and move forward with you. But again, you've got to think through it. And if your policy should define those kind, even if it's not job related. My recommendation, I think, in our standard policy is if in 18 months or maybe it's 24 months, if there are 3 offenses, even if they're unrelated to the job, that automatically puts somebody at medium risk, which means that they're medium risk. And so we're going to get a higher level of scrutiny before we make the hiring decision with them. As I said earlier, we're nationwide. There are some states and even cities that have rules about what you can and can't consider, when you can ask criminal history and when you can't. Your policy's got to be compliant with that. And that's why you're seeing a lot of nationwide employers just ban the box or take the criminal history off the application and only asking after they made an offer and things like that. And that's perfectly fine, except I've got enough clients in places like California and other places where you can't ask. And eventually what happens is you get down the road and then you ask about criminal history after you make the offer, and that criminal history is sufficient to stop you from hiring that person. And so, but God bless Texas, other than in Austin, Texas, there are no limits about what you can ask and when you can ask. So you can make a fully informed hiring decision in Texas at the application stage. Bottom line, review the whole applicant. Okay, none of us is just our criminal history. And I feel like sometimes these presentations I do around this stuff seems to beat up former offenders more than I intend it to. But my goal is for employers to look at the whole applicant, including their criminal history, and evaluate everything they offer you and evaluate the risk together. And the risk and the reward, and you're looking at the whole applicants, because as I said, none of us are just our criminal history. Well, unless you're Charles Manson or Ted Bundy, then you are just your criminal history. But most of them are your applicants aren't hardcore criminals. What they are is that people who just make really bad decisions about their lives, make really bad choices in the moment. And sometimes those things are directly relevant. Their decision-making ability, their ability to handle their anger, things like that are relevant to the job. And we're doing this webinar today on the same day that episode number 22 of my podcast drops, and it is on second chance employment. And it's with Cherry Garcia. She's out of Dallas, and her company, Cornbread Hustle, all they do is help former offenders and actually felons, people who were in prison, help. She's a staffing agency for those guys. Now all she does is help them find work, and she's amazing. Please go goodmorninghr.com. I don't monetize that thing at all. It's just me having fun conversations with very interesting people, but go listen to this episode. She makes really compelling arguments for being a second chance employer, and her story is just inspirational. And she is so transparent and open about her past and how it led her to start a staffing agency only for former offenders. I saw there were some questions about how can we get those tools that you showed earlier, and you can. They're on our website, imperativeinfo.com, and then just go /7, and that'll take you to the 7 steps to making bulletproof hiring decisions. And from there, you can download the instructions for how we use those tools, and also the tools themselves. And so feel free to avail yourselves of that information. And as I said earlier, I've got a podcast, and I drop a new episode every Thursday morning. Each one of them is worth half of a recertification credit from both HRCI and SHRM. And so you get a half a recert credit just driving to work. It's pretty cool. And every 2 or 3 episodes lately have been business credit for USPHRs. So if you need SPHR credit, there you go. We can help you with that as well. So let me look at, I don't think I've seen any new questions. Will the webinar and the PowerPoint slides be available? The webinar will be recorded. Oh, you know what I didn't do? I didn't turn on the webinar. I didn't turn on the recording. Did I not? Oh, I did. Good. I did. Good. So this will be on the website, including this little flub I just made, because I like coffee and that's what I do. But it'll be on the website, and so that'll be the way to get all of that. The slides are pretty much just pictures. You saw them, but the 7 Steps book has got a lot of that information, and the rest of the recordings are on the website. We did the 7 Steps, business case for being a second chance employer, and the 7 steps to bulletproof hiring decisions are already recorded. This one will be on the webinar or on the website in the next day or 2, and then as we go through the spring, the rest of them will be up there as well. Are there any other questions, or does anybody want to argue with me? That's always good too. Are there any questions or anything else I can answer for anybody? If not, then I appreciate everybody joining us today. If you have any questions, feel free to reach out to me or somebody in my company. We'd be glad to answer those questions. I do a lot of free consulting over the phone with folks, just trying to kick ideas around sometimes. But I also will come into your organization and sit down with your leadership and help you build out your policy. Because what I won't give you is a policy. Even I won't share with you another client's policy or things that would just automatically get you in trouble, because I don't want to give you the rope to hang yourselves with. And so, I'll give you the tools and you can build it yourself, or you can bring me in and I can make sure that what you're doing is consistent with what I'm seeing employers all over the country do. So thank you, everyone, for joining me, and imperativeinfo.com, or just catch me every Thursday morning at Good Morning HR. I'll talk to you soon. Bye-bye.